The courts don't stop, and neither do I. Not for speed bumps, and not to let my coffee cool down. Happy Aloha Friday, everybody. I'm Brian, and this is the Aloha Friday Morning Report for the federal courts, August 22nd, 2025. We survived another week. Grab your ulu or your lei. Let's catch up together. Please do me a favor, double tap your screen real quick, drop a comment, and if at all possible, if you're going to come back and watch later, at least watch the intro before you flip. It really helps get this out into the FYP, and this is a lot of work to do if nobody sees it. Now, I've got some good ones for you today, guys. I got a Supreme Court case, one of Donald Trump's inner circle got all but fired by a judge, and an update on two really major immigration cases, so let's get into it and we'll put a bow on this week, shall we? All right, first, U.S. v. Giraud. In a case in New Jersey, a judge has ruled that Elena Haba, the lawyer who represented Donald Trump personally in a number of cases and was appointed to serve as acting U.S. attorney for the state of New Jersey, was illegally employed as a prosecutor. Now, a U.S. attorney usually has to be confirmed by the Senate, but a temporary or interim person can be appointed for a short time if nobody's available or whatever. Ms. Haba was appointed through an interim appointment with no Senate confirmation, and then she's been kind of shuffled around in different interim positions so she can essentially stay in her job without Senate confirmation. And recently, a Senate defendant challenged their federal indictment because it had been signed by somebody without authority to sign it, namely Elena Haba. And the judge agreed. She's been in the job for more than 120 days, which is the maximum, and so anything she signs is not legally binding. So now she's been disqualified from prosecuting, from supervising prosecution, from participating in the supervision of prosecuting, and anyone acting under her supervision is subject to disqualification. So she is pretty stuck. It's unclear why she was never put up for Senate confirmation in the first place. We'll see whether the president sends her to the Senate or tries something else. I don't know. Next, there was a big decision out of the Supreme Court yesterday, but once again, the news overstated it a little and sort of lost part of the story. So, National Institute of Health v. American Public Health Association was a case that we discussed earlier this week. This was an NIH funding case where a district court ruled that the funding had to stay in place to protect the research projects while the case is ongoing. And the key question here was about irreparable harm that can't be fixed later, which the court wants to avoid while we do all this courty stuff that can take a couple of years. And the district court judge said, if you cut off this funding, these studies are going to close. You can try to pay them back later if they win, but there won't be anyone left there to pay. And a few of you in my comment disagreed with the judge. I do need to point out that historically, the judge's read on this is a little bit more traditional in this particular set of circumstances. Money can always be paid back, but we also usually balance in there whether the organization or project can survive without money during the meantime as well. And consider things like, is it a nonprofit or a business? That sort of question. So for those of you who disagreed, in a 5-4 decision, the Supreme Court went the other way and said, we can pay them back later if they win. So for now, the government can stop paying and they'll have to make it up if they lose the case. It does need to be noted, though, that this decision hung on Justice Barrett, who agreed with the majority, but for her own reasons. Not because the money could be paid back, or possibly that too, but primarily because she thought this case should have been brought in the Court of Federal Claims. It's a special district court just for dealing with claims about federal contracts and money and stuff like that. Remember that for a second. We'll come back to it in a moment. The court made a second decision in this case as well, which also might have some ripple effects. When the Trump administration took over, they implemented these anti-woke and anti-DEI policies, and they came into the NIH and rewrote the priorities of the agency and the rules for who should get grants based on those priorities. And the district judge said, no. There's a process for that. You can't just do that. And so the district court basically just threw out all of those changes. And in another 5-4 decision, with Justice Barrett changing sides, the court agreed with the judge. The judge definitely had the power and the discretion to review and overturn those changes. But Justice Barrett was kind of on her own in this whole case, and she divided these two questions in her own way. She thought, questions over whether the NIH properly changed its internal policies according to the law, that is classic district court. Mwah. The judge was just in the right spot with that one. Questions about appropriations and federal contracts, those, she said, belong to the Court of Federal Claims, and that's where she divided here. This was all about jurisdiction. One issue was perfect where it was, the other was in the wrong court. So if any of you are lawyers out there and you may want to brush up on your COFC procedure in the near future, it might come in handy. If anybody wants to read this opinion, it's in my shared docs with the SCOTUS opinions for August. So go take a look for yourself. Okay, we are going to wrap up with two of the most important immigration cases that I think we have right now. I think one of these is a name you're definitely going to recognize. One you may not know off the top of your head, but also incredibly important. Keep an eye on it. We're going to do J.G.G last, and we're going to start with Kilmar Abrego Garcia. I just reported on this a couple days ago. Basically, there's been back and forth with the feds because the criminal trial in this case isn't until January, and the court was just going to send him home. But the federal government basically said they were going to grab him off the street and send him back to that prison in El Salvador the minute he was out of court custody. So this guy asked the court to keep him in protective custody with the U.S. Marshals until they found a way to keep him safe. And he said basically he was going to hire a private security firm to make sure that they were going to keep him going to his court appointments and all that stuff. But more importantly, they were going to keep him safe from the feds. And the proposal that he gave to the court also came with a request that the judge order the feds to agree to certain conditions, like giving the court 72 hours notice before attempting to remove him from the country, and ensuring that he had physical, in-person access to his attorneys to prepare for trial. Well, the government released about the creepiest response I have ever seen yesterday. It sounds like it was written by the witch from Hansel and Gretel trying to convince you what a great babysitter she is. All right, the government says that, quote, they do not oppose and would not oppose the defendant having access to his attorney should he be taken into immigration custody by Homeland Security at a future point. We encourage your child to have all the candy and cakes they want while they access our special heated spa facilities. Quote, however, the United States would note that, pay attention here, should the defendant be removed from the United States to another country, somehow, via deportation, the United States would no longer be in a position to facilitate the defendant's access to his attorneys at that point. Once the spa hits 350 degrees, though, through no fault of our own, your child's warranty may be voided. So anyway, I don't love this. I'm assuming Abrego Garcia and his lawyers know what they're doing. He's got this whole security team, and I don't know, this may get much more interesting. We'll see. I absolutely encourage you to read this document for yourself. I know I made some jokes here, I apologize, but it's Friday. But seriously, go check this out for yourself. I put the filing in my shared documents, but you can also Google the case number, 25-CR-00115, and choose a link for Court Listener, and then you can read every document and make decisions for yourself. I am not required for this process. Okay, the last case is J.G.G. And I almost canceled the morning report this morning to just do a report on this alone. This is a class action about a number of Venezuelan nationals who were sent to a prison in El Salvador. And I spent several hours reading about this because it's an interesting one. But, okay, let me just give away the ending. There were a bunch of crazy procedural things going on because these guys were all in custody of the Salvadoran government inside of a prison. The American courts wanted them out, but the American courts also can't negotiate with other governments, and the president refused to do so. And I think the ducks were about to hit the fan, if you know what I'm saying. So, just when things were about to get nuts, the president of Venezuela and the president of El Salvador had this little prisoner swap, and all the plaintiffs were sent to Venezuela and are now either free or about to be. So they can just fly back to the U.S. for their hearings, and this whole crisis just poof. So this case was in the Court of Appeals, and yesterday the court recognized that the crisis just sort of disappeared. And it just dismissed all the procedural things related to forcing the federal government to spring these guys from El Salvador, all that stuff. It just said, okay, well, let's send this thing back down to the district court, and these guys can come back and have their next set of immigration hearings, I guess. Now, what's going to happen with Homeland Security if these guys try to get back into the country for their hearings? Oh, Aloha Friday, Brian. That is a problem for Caffeinated Monday, Brian, to deal with. You go enjoy your weekend, and that I will. That is your Aloha Friday Morning Report and a wrap on another week in the federal courts. So, fa'afatai Again, to those of you who've been sending me aloha through Venmo and Amazon and Linktree and other places, and everyone watching and commenting and liking, double tap the screen if you haven't. I really appreciate it. Mahalo for watching. Aloha, talofa. Have an amazing weekend. I will see you all on Monday. Manuia leaso. Have a great weekend.